5 for 2023. That also shows Mr. Khan as 100% shareholder. If you go to page 47, you'll see again, Mr. Khan is listed as the only person who gets a K1. That's Mr. Khan. And if you go to page 48, it also lists the goodwill of the company as $14,000 being amortized. Now let's go to 2024 tax return. Okay, 2024, I also cannot show you the K1. However, I am going to tell you that the K1 says Mr. Khan is 100% of the shareholder. He is the only percentage holder who got a K1. There's no other K1 in the 2024 tax return as well. Let's get two. If you go to page 70, that we can show. This is the summary of stock ownership. And this also shows Mr. Khan has 100 shares at the beginning of the year, 100 shares at the end of the year, and 100% of the stock in the business. And then if you go to page 72, that again shows only Mr. Khan as getting K1 compensation. You go to 73, it still only shows that $14,000 of actual goodwill. That's all. Good deal. Thank you. So as we finish up our conversation on what Mr. Khan testified about, there's a couple of things I want to make sure that are clear from what defense counsel is asking you to give defendant. First, they ask for $5,000. That $5,000 is an alleged short pay from the cash due at closing. Well, you've seen from the 3 checks that the closing the cash due at closing was paid in full, $150,000. They're not entitled to that $5,000. Next, they are asking for the $63,107. Well, as we've discussed, the parties both agreed to waive that promissory note payment. Why? Because of the COAM problem, the COAM suspension. They suspended the payments. Before the payments for the promissory note could resume, Mr. Ray was fired. And therefore, he did not have the ability to earn money from the business to pay the promissory note. Next, they're asking for $80,000. Well, that's the guaranteed profit. That, again, was suspended, just like the promissory note payments. There was no guaranteed profits because the parties made a decision to mutually depart from the requirements of the contract because of the COAM suspension, because they didn't have the revenue coming in to do it. Next, there's $128,292.50. Not a single piece of evidence was introduced by the defendant to substantiate that claim. Nothing. There's nothing in the record to explain to you what that money came from, what that money is for, or why you should award that money. Therefore, there's no evidence, so I think you have nothing to go on there, and therefore you should deny that claim. Next, they're asking for $61,979. The same thing. They presented no evidence to support that claim. And therefore, I would submit that you can't award damages for anything that they don't have any evidence for. Especially just because you put it on the board doesn't mean it's there. And it was not there. So that finishes up Mr. Khan. After Mr. Khan, we put Mr. Ray on the witness stand. And he told you about his history of working in convenience stores. The fact that he had come to America, found his niche, worked in several stores, owned his own store, and ultimately formed the partnership with Mr. Khan. He had partners before. He had partners at Bell's, which was his first venture owning a convenience store. So he was not afraid to go into a partnership. I would submit that Mr. Ray's fault is in being trusting. He trusted Mr. Khan too much. He should have insisted on getting financial documents in the beginning, but that's really not at issue here today. The only thing that is really at issue here today is whether or not the defendant, Mr. Khan, transferred 49% ownership interest in Nahar to Mr. Ray. If you answer that he did not transfer it as as the tax returns show, and as everything else shows, then your answer and your job is easy. You rule in favor of the plaintiff, Mr. Ray, and you award him the damages that we're seeking. Now, Mr. Ray talked about entering into the agreement. He talked about the fact that the agreements were written by Mr. Khan's attorney and that they went to Mr. Khan's attorney to sign all the documents. He talked about the fact that he wasn't really given a chance to negotiate, that he was given the documents, he was given 10 minutes to read them, and then he had to sign. It's a very swift process. Now, there's no doubt Mr. Ray should have said, stop, hold it, stop everything. I want to read this. I want to get a lawyer. He didn't. And so that is part of the reason why he was able to be taken advantage of. And I think that's a shame because the law is not built to help people like Mr. Ray, not built to help people who generally do not read their contracts. But in this case, not only is he able to recover, he's able to do so because Mr. Khan didn't do his job under the contracts. Now, Mr. Ray, when he's on the witness stand, also explained what happened with the COAM systems, the coin-operated amusement machines. This is machines that you see in many convenience stores, and people go in and play them. Yes, the evidence is that you're not supposed to pay cash prizes to the COAM winners. However, all of the convenience stores do it. All of the convenience stores did it, have done it for years, and it's not right, but it's how you have to compete. Mr. Ray testified that the Chevron had COAM machines before he came to work. They paid cash prizes before he came to work. While he tried to police it, he also testified it was a new employee who was the one who paid the cash prizes. So we can't stand here and say that cash prizes were never given out except for that one time. But we can tell you that it's sort of a standard operating procedure. And more importantly, when the license was suspended, Mr. Khan didn't come in and say, you're fired for breaking the law. No, Mr. Khan came in and said, okay, it happens. Let's see what we can do to get around it. Let's work on the future. And it is that working on the future that created the agreement to suspend the payments on the guaranteed profit and the promissory note. I'm not here to excuse breaking the law. I'm not here to say that Mr. Ray shouldn't have been more diligent in enforcing the law for his employees, because he should have. There's no doubt about that. But what I'm saying is that Mr. Khan recognized the problem. They worked together to fix the problem. Mr. Khan clearly, through his actions, did not blame Mr. Ray for having the license suspended. Why? They cooperated on a solution to handle the financial impact of the license being suspended. Now, Mr. Ray took you through these contracts as well. I don't see any reason to go through that again because I think you saw what Mr. Khan explained, what Mr. Ray explained, and the documents, of course, are going to go back with you in the room. I think Mr. Ray did testify. He signed every document they put in front of him, that he did what was asked of him. He signed all the contracts. He paid the $150,000 cash due at closing. He paid the $50,000, which was the earnest money. He did what he was supposed to do to earn that 49%. Let's go to Exhibit 20. So Exhibit 20 is a summary that we created for all the checks. Exhibit 20 is on, sorry, page 65, I think. There it is. Can you blow that up a little? Good. So the checks that we got, maybe a little bit more. Thank you. There we go. So the checks we got really were sorted into two categories. The categories on the left are the vendor checks. Now you heard Mr. Ray testify. He had to write these checks from his own bank account because Mr. Khan did not give him a checkbook. And more importantly, did not give him checks that were signed by Mr. Khan. Remember, Mr. Ray never got access to the bank account, never got online access to go see what the balance is and see if he could write checks. He never got the authority to write checks. And more importantly, he never had checks to write. When Mr. Khan did not give Mr. Ray checks, he had to write a check from his own pocket. So that totals $15,982.83. We're asking you to give Mr. Ray restitution of that $15,982.83. The second column to the right are the payments that he made directly to Mr. Khan, and that totals the $331,750. I believe that is the wrong version. Do you have the other Exhibit 20? So that version is missing those two checks again, that $95,000. So if you look at why don't you put that up? This is a summary that we showed you at the very beginning. In this summary, it shows the payments that were made on the left-hand side, they were made to all the defendants, which total $331,750.43. That includes the top two checks are the earnest money checks. And then the next three checks are the checks that were for the cash due at closing. And then the other checks were checks that Mr. Ray made to Mr. Khan during the course of his management of the business. And the final check is to TSTT Development for $85,000. If you recall, Mr. Ray said, Mr. Khan told me to write the check to TSTT. Mr. Ray said, I never heard of that company, but if Mr. Khan wanted me to write it to them, that's what I'm going to do. In fact, most of these checks were written as directed by Mr. Khan. Mr. Ray did what he was supposed to do. And then if you look at the column to the right, you'll see the $15,982.83. Those are the checks written to the vendors. And so the total that we're asking for is the $347,733.26, which is the restitution that we're seeking. Now, those are the payments that Mr. Ray made. What did he get out of the deal? Well, remember, Mr. Ray testified that when he worked in the convenience store, he was the boss. He was the operations guy. But once the COAM license was suspended, Mr. Ray had no choice but to work. He had to become an hourly worker. He had to work a shift. And so he got paid as an employee. And if you will recall, Exhibit 24, which is on page 86, these are the tax documents he got for his work. And this first year, he made $18,000. The second year, that's on page 86. There we go. He made $18,000. $630. The second year, he made $14,720. And then he got 1099 income of $17,000. In total, he made $40,000 in wages. Now, he testified this had nothing to do with what he had as a deal for the convenience store. It had nothing to do with this 49%. It was only about him providing work in addition to his duties as the manager. If you recall, Mr. Ray testified that he had to work every single day of the week, that he worked 8 to 12 hours every day of the week, that he was not only running a shift, he was there placing orders and doing all the other administrative duties he was supposed to do. Mr. Ray testified he never got any stock certificates. He never got any evidence of the 49%. Defense says, well, it's all in the contracts. He didn't even get the contracts. There was no anything, no documents, no evidence, no nothing to show that Mr. Ray was an owner of the company. Never got access to the bank account. Never got the right to sign checks. Never got online access. He never had any evidence of owning the company. Go back to the slideshow. So at the beginning of this case, I told you that we were going to do certain things. I want to just recap our slideshow. Let's go to the one before. One before that. There we go. Nope, other way. There we go. We introduced the parties. We showed you the agreements. We showed you that Mr. Ray was an experienced store manager and operator. We showed you that he paid over $347,000 to Mr. Khan. Mr. Khan confirmed the payments. We showed that that Mr. Ray personally ran the business and managed the day-to-day operations. And we show that Mr. Ray was fired by Mr. Khan, despite no wrongdoing on his own part. He received nothing in return. No ownership, no profits, no payments, no losses, no nothing. We told you about the defendants, particularly Mr. Khan and his company in Nahar Investments. Go to the next slide, please. We showed you and talked about the convenience store at length, the fact that it was a Chevron gas station, and the difference between what he was promised and what he received. Let's go to the last one. So at this point in time, we're asking you to grant restitution to Mr. Ray, to give him the money that he has paid, the $347,733.26 to unwind this deal. Now, I think it's important to close on the idea that this is a subject matter of unequal bargaining position. And Mr. Ray did not have the power in this. And so that's why he is sitting here with, paid $347,000 and got nothing to show for it. Now, that unequal bargaining position stems from a lot of things. Mr. Ray is a trusting guy. He trusted Mr. Khan to treat him fairly. He's a hard worker. He runs a convenience store, not sophisticated, did not know that he should go in and question everything. He did not know that he should not trust Mr. Khan. He did not know he should not trust Mr. Khan's lawyer. Now, Mr. Khan testified that the lawyer worked for both of them, but that's not true. The lawyer worked for Mr. Khan. Mr. Ray may have helped pay for the cost of the lawyer, but there is no doubt that the lawyer who drafted the documents did so for Mr. Khan, and the documents clearly favor Mr. Khan. Just a provision alone that says that Mr. Khan didn't have to give Mr. Ray any of the documents clearly shows that the lawyer was working for one side and not the other. Despite clear warnings, Mr. Ray continued to go forward with this deal. Never got the documents at signing, never got any financial information, never got access to the bank accounts. Those are pretty clear yellow flags, as Mr. Ray pointed out to you. It's clear from the actions of Mr. Khan and the tax returns and all the testimony and the documents that Mr. Khan never transferred 49% ownership interest of the company to Mr. Ray. If you were to say, Matt, what is the breach of contract? The breach of contract is clearly the failure to transfer 49% interest in the company. There's been a lot of testimony about a lot of other things, but at the end of the day, that's what's important. Did Mr. Khan do the one thing he had to do? Did he transfer that 49% to Mr. Ray? The answer is no. And if you find the answer is no, we ask that you give us $347,733.26 plus attorney's fees. I want to thank you again for being so kind as to listen attentively. I am thrilled to have a jury that is paying attention and taking notes. I'm thankful for the process, and I want to thank you for doing your civic duty. Thank you. I have nothing further, Your Honor.
Thank you, counsel. All right, members of the jury, it's now my duty to charge you on the law that is applicable to this case, and I have to read that to you, and this process takes about 10 to 15 minutes. Does anyone need a break before we dive in? All right. Seeing none, then I'll begin by saying you are considering the case of Dinesh Ray as plaintiff versus Mohammed Tuan Khan and In-Nahar Investment LLC as defendants. Plaintiff filed this action here in the Superior Court of Fulton County, in which he brings claims against the defendants for breach of contract. The defendants bring a counterclaim against the plaintiff for breach of contract. I'll also note you'll receive a copy of these charges along with the exhibits we're able to provide you. The party bringing any claim must prove every essential part of its claims by preponderance of the evidence. This is sometimes called the burden of proof or the burden of persuasion. Preponderance of the evidence simply means an amount of evidence that is enough to persuade you that the party's claim is more likely true than not true. If the proof fails to establish any essential part of a claim by preponderance of the evidence, you must find against the party making that claim. When more than one claim is involved, you should consider each claim separately. In deciding whether any fact has been proved by preponderance of the evidence, you may consider the testimony of all of the witnesses, regardless of who may have called them, and all of the exhibits received in evidence, regardless of who may have produced them. If the proof fails to establish any essential part of a party's claims by preponderance of the evidence, you must find for the defendant or counter-defendant as to that claim. Evidence is the means by which any fact that is put in question is established or disproved. Evidence includes all the testimony of the witnesses, as well as the exhibits admitted during the trial. Evidence may be direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a chain or set of facts and or circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You, the jury, must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witnesses' manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. The credibility of a witness may be attacked by disproving the facts to which the witness testified. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pre-trial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. A contract is an agreement between two or more parties for the doing or not doing of some specified thing. To constitute a lawful contract, there must be parties able to contract, a consideration for the contract, the agreement of the parties to the terms of the contract, and a lawful subject matter. A consideration is valid if any person who promised is entitled to a benefit or any harm is done to one who receives the promise. A person is bound by any contract he signs without reading, unless he can show, one, an emergency at the time of signing that would excuse his failure to read, 2, the other party misled him by an artifice or device which prevented him from reading. Or 3, a fiduciary or confidential relationship existed on which he relied in not reading the contract. When parties in the performance of a contract depart from its terms and pay or receive money under such departure before either party can recover for failure to carry out the exact terms of the agreement, reasonable notice must be given to the other party of intention to rely on the exact terms of the agreement. The original contract will be suspended by the departure until such notice. In order for this rule to have application, it is necessary that the circumstances be such as will in law imply a mutual new agreement, whereby new, distinct, and definite terms are supplied in lieu of those provided by the original contract. The departure from the terms of the contract must have been substantial, and such as to make it inequitable for the creditor to demand without previous notice all past due payments, or to proceed to collect by suit. Evidence of the buyer's repeated, late, irregular payments, which were accepted by the person to whom payment was due, is a factor for your consideration in determining whether a new mutual agreement is to be implied. As a general rule, there is implied in every contract for work or services a duty to perform it skillfully and carefully. The law requires persons undertaking to perform services requiring skill the duty to use that reasonable degree of care, skill, and ability that would be used under similar conditions and circumstances by others of the same business or profession. In the absence of misrepresentation or fraud, ignorance of a fact known to the opposite party will not justify relief, unless there is some reason why the injured party should have relied on the opposite party for information, and in so relying was deceived either by conduct or words. Ignorance by both parties of a fact shall not justify the interference of the court, nor shall a mistake in judgment or opinion merely as to the value of property authorize such interference. Damages are given as compensation for injuries sustained. Damages recoverable for breach of contract are such as arise naturally and according to the usual course of things from the breach, such as the parties contemplated when the contract was made as the probable result of the breach. Any necessary expense that one of two contracting parties incur in complying with the contract may be recovered as damages. Remote or consequential damages are not allowed whenever they cannot be traced solely to the breach of contract or unless they may be computed exactly. The object of giving damages to the injured person is to put him in as good a position as if the breaching party had fully performed the contract. Restitution damages are an alternative remedy for breach of contract. The object of restitution is to return the injured party to the position he occupied before his performance. In other words, to restore him to the pre-contract status quo. A party entitled to restitution may recover the reasonable value of materials furnished and services rendered, measured as of the time of performance. When by a breach of contract one is injured, one is bound to lessen the damages as far as practicable by the use of ordinary care. In every case of breach of contract, the party not breaching it has a right to damages. But if there has been no actual damage, a plaintiff can recover nominal damages that will carry expenses of litigation. When considering the amount of nominal damages, no particular award is required. However, it must be a trivial sum, important only for the fact of the award itself, but not meaningful for its amount. The expenses of litigation are not generally allowed as part of the damages. But if the defendant or counter-defendant has acted in bad faith, or has been stubbornly litigious, or has caused the plaintiff or counterclaimant unnecessary trouble and expense, you may allow them. You do not need to determine the amount of any attorney's fees or expenses. The parties have entered into stipulations that have been approved by this court regarding the amount of their attorney's fees. Bad faith arises out of the transactions upon which the complaint is based and refers to a time period prior to when the lawsuit was filed. Stubborn litigiousness and causing the opposing party unnecessary trouble and expense refer to forcing either party to file a lawsuit when there is no bona fide controversy. If there is a bona fide controversy between the parties, expenses of litigation should not be awarded unless you find that the party against whom the fees are to be awarded acted in bad faith. Bad faith is the opposite of good faith. Bad faith exists when one is not acting under a genuine claim of right, whether the claim is founded or unfounded. Bad faith is not merely bad judgment or negligence, but it imports a dishonest purpose or some moral obliquity and implies conscious doing of wrong and means breach of known duty through some motive of interest or ill will. I want to emphasize that anything I did or said during the trial of this case was not intended to and did not intimate, hint, or suggest to you which of the parties should prevail in this case. Whichever of the parties is entitled to a verdict is entirely a matter for you to determine, and whatever your verdict, it must be agreed upon by all of you. My interest in the matter is that the case is fairly presented according to the law, and that you, as honest, conscientious, impartial jurors, consider the case as I have instructed you and return a verdict that speaks the truth as you find the truth of this case to be. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given to you in this charge. You're not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, or sexual preference, local or remote residence, economic or corporate status, for or against either party. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or media to communicate to anyone any information about this case or conduct any research about this case until I accept your verdict. Your verdict must be unanimous. One of your first duties in the jury room will be to select one of your number to act as foreperson, who will preside over your deliberations and who will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind. Jurors should carefully consider all the evidence in the case and deliberate with a view toward reaching a unanimous verdict consistent with your consciences and oaths as jurors. Avoid premature, fixed opinions. Consult with one another and consider each other's views. Each of you must decide this case for yourself, but should do so only after a discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if convinced that it is wrong. However, you should never surrender honest convictions or opinions in order to be congenial or to reach a verdict solely because of the opinions of the other jurors. In just a moment, you may go to the jury room, but do not begin your deliberations until I send you the exhibits and verdict form, which I will do shortly. Then you may begin your deliberations. And so, as I've mentioned, we have and we'll provide you with a pre-printed verdict form that should indicate just each of the findings that we ask you to make. Please follow the instructions listed on here and sign and date once you've concluded your deliberations. Any objections to the charge other than those already preserved during the charge conference on behalf of the plaintiff?
No, Your Honor.
And any on behalf of the defendants?
No, sir.
All right. And so at this time, members of the jury, I'll ask you all, with the exception of juror 29, to retire to the jury room. 29, if you could stay behind with us.
The jury.
Juror 29, if you could stay with us. Thank you. Feel free to have a seat.
For how long?
Just a minute. All right, juror 29, you may have noticed a jury is composed of 12 people. There are 13 here. You are our alternate. And so there, at this time, I'm going to allow you, excuse you for the day. You can get your things, collect them, and leave. Go about your business. There may still be a scenario, though, where we need to call you back and sub you, and it's unlikely, but it could happen. So we're going to give you a call and let you know when you're officially excused from jury duty. And so if for some reason the jury hasn't reached a decision tomorrow morning and they need to bring someone else in, we may be giving you a call. Do you have a conflict tomorrow morning we need to know about?
I can get the call. The question, how soon I need to respond?
So I would ask that could you be, remind me what part of town you live in?
Johns Creek.
Johns Creek. So that's quite a ways out. Do you think you could be back here if we were to ask you within 2 hours?
Can try.
Okay. So again, it's unlikely, but we want to just let you know that you're not officially released from jury duty until we give you that call. But for now, if we don't see you again, want to thank you so much for your time here today. Feel free to get some food on your way out of here, since I think we have some of that here. And if we don't see you again, thank you again. Do you have any questions for us?
No, I think I'm free to leave now.
You are free to leave now. Take care, sir.
Thank you.
All right, so returning to the issue of the exhibits, a plaintiff had provided a binder with everything they thought should go back. Defense exhibits that were admitted were, I have on my notes, D6, D7, and D9, which is the attorney letter, the complaint, and the interrogatories. As I think I've already indicated, D7 and D9 wouldn't go back. Is there an agreement on 6?
One moment.
That's a complaint.
6 is the letter.
Oh, the letter, right. Yeah, that was tendered.
6 going back, right?
Yeah.
If there's agreement by the
Yeah,
parties.
7 and 9.
All right, any other objections or issues with the plaintiff's proposed exhibits that go back?
Only, Your Honor, and I may have missed this. I didn't show that plaintiff had moved to admit exhibit 16. I know it's.
Yeah, I do not have 16 on my list of tendered exhibits.
Okay.
Is that the only one?
And actually 17 as well, but I think that was tendered.
I do have 17. That's their
I think
attorney
that was my
letter.
mistake. All right.
All right, if there are no others, then I would ask, just have that binder and the other D6 added to it.
I thought the complaint wasn't going back, but the interrogatory responses were.
That's not my understanding. The site I have for that is going to be Kresge, 160 Georgia Appeals 219. And in Georgia Civil Discovery saying written statements such as interrogatories, depositions should not be unduly emphasized by giving the jury an opportunity to read them one or more times after hearing them read in the courtroom, whereas oral testimony from the stand is heard only once.
Can't trust those Czechoslovakians, so don't worry about Creighton Crest.
Yeah, I hear you. So I mean, you can note an objection for the record if you want to. Feel free.
No, I understand, Judge. Thank you.
Okay, so we've got everything added, and I'll put the verdict form and the charge on top of that, and Deputy Scott will send that back.
Yes.
You already redacted the statement.
We did read that.
We need,
Tax return on the one that you gave.
Ms. Sue, do you have a Sharpie or something like that we can use to redact these tax returns?
We already did that.
Pardon me?
Yeah, we did that.
You did?
Yeah,
Okay.
while we were at the table.
Oh, great. You want to
You
just
don't
sub out? You already did it.
With the one you showed.
Okay. Big 7, I think was the first one.
Okay.
Oh, these are not numbered. Oh, okay. So you already did.
Yeah. So I think
Great.
we- I think
Oh, that's what you were doing. I got it. I see
Yeah,
it.
yeah.
All right, Judge. Yes, Your Honor, this has been redacted. Thank you.
All right, so Deputy Scott now has all the exhibits. I'll ask him to go back and he can inform the jurors they can begin their deliberations at any time. Because I imagine they're working through lunch, let's stay within reach 5 to 10 minutes. We'll send you an email if we get notes. And other than that, is there anything we need to take up before going into recess on the part of the plaintiff?
No, Your Honor.
Defendants?
Just to be clear, I understand that Mr. Collins was saying in his closing, the only thing that matters is the 49% breach. Is it going to be on the verdict form that to find a breach just means that one thing that they're, because I'm just worried that they could think, since he did start talking about getting fired, could it be a breach to say that he was fired wrongfully? And we've pigeonholed this to the only breach would be non-performance of giving 49% ownership to the plaintiff.
I think I was pretty clear on that front, Judge.
In your closing?
Yes, sir. I think I said about 5 different times that the only issue is whether or not they, Mr. Khan transferred 49%.
I agree that those words were said, but then that was my concern about going into the firing and how depressing it was to get fired and so on and so forth.
All right, well, I agree. I think if as the position of the plaintiff is explicit on this, I think this could be tailored on the verdict form. And so we can retrieve it and give him another. And I could tailor it by saying on question 1 as to whether the defendants breached the contract with the plaintiff by, and you tell me the wording.
By failing to transfer 49% interest in the company?
Any objections to that language?
I just think for a minute here.
So if you're looking at your verdict form, it's going to be question one.
I would prefer to say by failing to make the plaintiff a 49% owner of the corporation.
I'm not sure. I disagree with that language because that is not really what was required.
Let's look at the agreement or the actual phrasing from the contract itself.
I mean, section 1, ownership interest. Buyer agrees to buy 49% membership interest of the company. So I think it should just say by failing to make him a 49% owner of the company.
I would lean towards by failing to sell. I mean, that's what,
Yes.
that's what the contract says
Yes.
it's going to do is
Yes.
sell it.
Yes, I like that. Thank you, Judge.
I mean, the contract says that he's going to sell. Does that necessarily mean he actually did sell or transferred?
Well,
I
that's
think
why-
it's really is transferred is the key verb here. Did he transfer the shares?
See-
Not did he sell them? The contract says he sold them.
No, because like Mr. Collins said in his closing, there's all these different things that can evidence this, there, or that to show. Think like, here's a piece of paper that says this has been transferred to you. It could be a stock certificate, but as you correctly pointed out, it does say sell. So it's only a breach if we didn't sell him 49%. Now they can think of whatever evidence they want to that in their mind thinks that he wasn't sold 49%, but that is what it says in section 1. So.
Well, look, we can, this is what lawyers do well, is getting into definitional disagreements. I think perhaps I could broaden it and just say by failing to perform
There you go.
regarding the 49% interest.
Can you say failing to perform the sale of the 49%?
I think the point of
interest?
broadening it would just be to allow that for them to interpret whether he performed under the agreement.
That's fine
Can you
with
say it
us.
one more time, man?
Well, let's see, by failing to perform and either regarding the 49 interest or some other kind of phrasing, just to say that we're directing their attention to the 49% interest and whatever the contract, as they find it to be, required the defendants to do as it relates to the 49%.
How about this? By failing to perform in the sale of the 49%.
All right, I'll consider that, Mr.
Well,
Collins.
I mean, I would say by failing to perform, maybe you say perform as required in the contracts regarding the 49%.
I don't care if it's performing
Regarding the,
performing in the sale of the 49% interest as required in the contract.
but the contract requires him to transfer the 49%.
Sell, it says sell.
Well, where does it say that?
It just says
I mean,
sell.
it's,
Contract just says sell. But I mean, the issue
doesn't say
is,
sell either, though.
And the section
Yes.
1,
I mean, it talks about sale all over the place. But the question is, what is a sale of a share? Does that include a transfer or does it just mean,
means
so
performing
Right.
the sale of the 49% as required by the contract.
I'm just gonna make it broader so that the purpose is achieved here. As to whether the defendants breached the contract with the plaintiff by failing to perform their duties regarding the 49% interest in the company.
Can't be duties to sell the 49%.
I think that's where the point lies. That's where the disagreement is.
That's
What does it
acceptable.
mean to sell? What is conveyed in that?
All right, can you read it to me one more time
Sure.
then?
As to whether the defendants breached the contract with the plaintiff by failing to perform their duties regarding the 49% interest in the company.
I think that's acceptable to us, Judge.
Sounds like your mind's made up, so I'm
All
gonna,
right, yeah.
yeah.
All right, your objection's preserved though. All right, if we could reprint the first page, we'll ask Deputy Scott to go retrieve that verdict form and we'll sub it out. Oh, okay, let me just print it here.
So I want to make sure you have my cell phone number.
That'd be,
Well, I'm gonna shoot an email to everybody.
Okay, good.
let's say he chooses not to appeal. Or let's say we appeal and we appeal, okay? Then I feel comfortable as an attorney telling him.
It's gonna take a minute.
They won't let me do it.
Madison, so let him.
Yeah, these are our exhibits. Oh, yes, we didn't give this to the court reporter. So,
Go ahead.
yeah, so Your Honor, with
Yes, sir.
respect to defendants exhibit 7 and 9, the court reporter obviously isn't physically here. We tendered those into evidence. They're just not going back with the jury.
Exactly. They're
So
part of the record.
what should we do with these?
Well, that's up to y'all. I believe,
I guess we can submit it.
I believe after trial, y'all are responsible for coordinating with the court reporter, perfecting the record, filing the exhibits that you need to file.
We'll upload them like we do on a deposition to Veritex. Have you ever used Veritex? They'll provide us a link. They'll provide us a link. Judge, are you going to issue this as a new court's exhibit number?
Which one's that?
The verdict form?
Yeah, I hadn't marked that one because we're going to get it back from them when they wrote on it.
We'll mark it.
So we've just got 1 and 2.
I got
And
it.
then I'll probably just end up filing it. We don't need to get that to the court
Okay,
reporter.
thank you.
Good.
So give me that.
Yep.
Because that's a full one.
Yep. All right, unless there's anything else, then we will be off the record and in recess until we hear from the jury.
Judge, what do we need to do with the court reporter?
I think she just needs to stay on Zoom.
Okay. Madam Court Reporter, can you hear us?
Yes, sir, I can.
We need to get your phone number so we can call you in case you step away.
Okay.
What
It
is
is
that?
it's gonna be 509
Okay,
899
okay,
5254.
5254. Okay, well, thank you for your help. Just hang loose, I guess.
Sounds good. Thank you.
All righty, bye. Okay.
There's a chance, honestly, they're just gonna see that and go, oh, all right.
So let's go step in our conference room.
Yeah, thank you.
The reason why this one that we just have to get is I'm gonna get rid of the papers. Cause that one,
Okay.
our version that has all.
Thank you.
That would be a reminder, oh, how come this one's so faint? So this is the one that.
Okay.
I think Ann.
It's just Tico and Michael.
I mean, she's probably just having some lunch now or something. I don't.
Joe probably took her out to lunch or something. Yeah.
He's like, Zach's not here. This is my chance to
Yeah, it's my chance to score.
try to hang out with one person.
Oh, you're Italian. Let's talk about that. Cause I know he talked to her about Italy for like. a fucking
Yeah,
40
I'm still
minutes.
trying to figure out how on it, because obviously her Her dad's last name is obviously not Italian. So I'm trying, and I've met her dad's parents before and they don't. So I'm just trying to figure out, other than her mom's side, which is
Yeah.
my side, I don't know what else the Italian thing is.
She's like,
Look at
really,
that
you're Italian
CSM
too?
Investments case.
Do what?
Your case. Justin's on trial, CSM Investments. Scott, so I are both on it.
Oh yeah, we never took a bet on the over under of the amount of days that it's gonna take.
Till someone
And-
says,
And,
hey,
and I'm
baby.
gonna be generous. I'm gonna be generous.
So we.
I'm gonna include in the pool, it could be any of the
Well, me,
clients, any of the clients.
To you or me?
To me, any of the clients, Scott or Leah. I'm just, the over under how many days it'll pass before they're like, first of all, that they even actually had the balls to be like, yeah, it didn't work out. Tell me that it even happened. And then they'll say, oh, but Ryan sent that email. But the bet would be, how,
repair with Scott Fitz.
yeah, the bet will be, how long will it take before they're like, oh, or something about doing something for the kids. I mean,
I'll just do that later. I'd say week, no more than a week.
yeah, a week is probably a good bet, like over under a week. That's
Mhm.
probably a good bet. All right, this might sound confusing. I'm gonna try to make this sense, okay? So. Even if they say. Sure. Sure.
Oh, we gotta hold it down. And that's it. I mean, you have to hold this down. Okay, before it was sticking.
Oh, bad, sure, we'll go. I give you
20 minutes.
Check purpose, you know, but it has a check.
They're lying about the check, yeah, I know.
Yeah, all right.
I know. Look, that's why we keep trying to say, it doesn't make sense, they have to be lying about the check. The checks add up to more, so it's more than what the purchase price is, and not only do they add up to more than what the purchase price is, they add up to more than what the purchase price is without him even paying the promissory note. So can you imagine if the promissory note, then it would be like closer to $400,000 instead of 260. You see what I'm saying?
Yeah.
So they're already
My
at,
question is, do you not understand? You know, they're thinking that.
well, that's why that's why in the closing, for instance, just like I did on his cross yesterday, that's why I'm saying, how could. All right, let's go. Where's the sun? We need to- You don't need to bring that on the trust, or
You can just leave it.
you can leave your ledger.
Oh.
You don't need to bring, I understand what's
Now
in.
my question, this one video, this is 100% true. You know, whatever they are say, are wrong.
All right,
They write the check, they use the bank account. The
okay, so what I'm saying.
And
what I'm-
also the video is going on the day.
Does it show who the money? I'll just go through those one more time. I've heard actually.
Remember, now y'all live, you might want to mute this button when y'all talking.
Okay.
So. It's live, so he got YouTube live. Yeah. So the folks who watching,
But the jury can't hear, right?
not a jury, not they can.
Hi, this is Justin Alware. Richard Ryan Alderson.
Going cash payout for non-kids.
Okay.
It's really exciting.
It's like a church.
Yeah.
See that? Gotta get some of this shit stuff. So I go grab a drink.
Or going. Just gotta look at that.
Things are.
All food, I gotta burn some calories. You going around with a cafeteria?
Yeah.
Might as well just finish watching these videos and finish this case.
You got my number to call.
Yes, yes. Not very exciting.
What is that?
It's for a cash payout case. I just got these to watch.
I did not get enough sleep yesterday. Stay there, I'll show you something. I'll show you something. So, just to show you, so what I mean is like, let's say that they say, yeah, we think that you, or we think that the company owes money, right? They have three options. That's what I'm trying to say. This just means like $1. Like technically we breached the contract, but he doesn't really have any damages, so we're just gonna put down like $1. Does that make sense? Does it? There's no point in me keep going if you don't.
I don't
No,
know.
so, well, then don't say yes. Okay, look. Nominal damages means that's the jury saying. Well. um, So, nominal damages, that's the jury saying, technically, we think that company breached the contract, but we don't think that the plaintiff showed any actual damages. So we're just gonna put down like $1 or $3. That's what nominal means. It's like a trivial amount, okay? We're gonna skip this one. Actual would mean, okay, we think defendant breached the contract, and we think that based on that breach, there was money that the plaintiff was supposed to give that he didn't give. And we think that that amount is whatever. That's what actual damages. Does that make sense? So like, let's say I was making $5,000 a month and I sued because I think that I was wrongfully terminated. And I was supposed to work for another 10 months. So that would be $50,000. So let's say I won the lawsuit, then the jury would say, well, we did, he's owed $50,000. Does that make sense? So actual damages means we breached, and this is the amount of money that we should have gotten if we hadn't breached, okay? Now, personally, this should be zero, because there's no money that he would have gotten that he didn't get. Does that make sense? This is the one that we keep fighting about, okay, this. This should not be an option. This means Yeah, make some calls. I guess that's muted, that one's not. I don't know why they had this.
So I saw that you had put an autoresponder on your emails.
I think it's Tim.
Oh, Tim had?
Yeah.
Oh, I have, yeah.
I was thinking about that. Has that worked out for you?
Yeah,
I
I just
don't-
learned to do that. I wasn't. took
Yeah,
a
I've
few
never
years.
done that for trial calendar, but I thought that was a neat idea. You think people stop bothering you?
Yeah, that's basically.
Well, that's the goal.
I need it on my phone though, too.
Yeah, can you do an autoresponder
Yeah.
for text messages?
Only. You can probably download the app. Third party app.
Yeah, I'm in trial right now. I will talk to you when I'm ready.
Or at my earliest convenience.
Or at my earliest convenience. Um, Madam Court Reporter, can you hear us?
Yes, sir, I can.
Okay, great. We're about to go back on the record in a few minutes.
Okay.
All right, do we have our court reporter?
Yes, sir, I'm here.
Wonderful. All right, we are back on the record. I believe the jury has been deliberating for about an hour. I think they got the case right at 12 o'clock.
They got it. I got it. When you told me the time.
They start delivering 12 o'clock.
Oh, all right, sure.
And now we have received a written question, which I will mark as Court's Exhibit 3, and I'll read it into the record. It says, we request clarification on LLC business structure where LLC ends and member begins. Does commingling of personal and LLC assets / expenses negate LLC member protections? And I believe it's signed by one of the jurors, presumably the foreperson, and dated. So the parties can come inspect that, and then I'll entrust it to the plaintiff's care. All right, and so any initial input from the plaintiff?
Yeah, I think I would answer the question with a statement of the law. Did we keep that jury charge in? I thought we had.
I
pulled that
didn't,
out.
I had pulled that out, the non-pattern charge on veil piercing.
I think that you would answer the question by providing that that charge that you were going to give. Because I think that really is the answer.
Seems on point, and someone back there seems to know a lot more about corporate law perhaps than the average person. Any input from the defendants?
Yeah, Judge, I think we just need to tell them the evidence is closed, the charges have been given. There's nothing else. There's no curative instructions necessary. That wasn't one of the charges that was given to him.
Certainly agree the evidence is closed. This is to me a different thing. If there's law that's applicable and that could be applied to their consideration here, I would think I have to give it, or should rather.
I disagree, Your Honor. I mean, I think that was the reason we decided we weren't going to give that charge because there was no evidence about it. This is the jurors using their own, I think they've deviated from what the evidence is. And they're, so I think we just need to tell them, look at the charges that you've been given and make your deliberations from that.
All right,
The original.
sure.
Okay, thank you, Judge, that's fine.
All right, so guided by the instructions that charges are supposed to fully and fairly encapsulate the law applicable, adjust it to the evidence, be a correct and complete statement of the law. By the nature of the case, we have an individual with a breach of contract claim lodged against him, as well as an LLC, and that LLC is majority owned by that same individual. I think veil piercing, whether or not explicitly brought in the complaint, is part of this case, and how to distinguish between the two. And so I would give over defense objection the veil piercing pattern charge. I'll add to it that they're not to place any greater emphasis on this charge, and it should be only considered in the context of all the other charges they've already received. And I'll remove the emphasis on Muhammad Tuhin Khan, and I'll just say whether a party, because I suppose it could also apply to the counterclaim as well. And so with that, Deputy Scott, if you could give Court's Exhibit 3, which I've tendered to plaintiff's counsel, and we'll bring in the jury. Feel free to have a seat as you come in, members of the jury. Thank you, Deputy Scott. Members of the jury received a note from you asking for clarification on a point of law. And in response to that, I will provide this additional charge for your consideration. However, I'll note that you should not place any greater emphasis on this charge than any of the others that I've already given to you, and just consider this charge in the context of all the other charges as well. And so, in response to your question, I charge you that a corporation possesses a legal existence separate and apart from that of its officers, and the mere operation of corporate business does not render one personally liable for corporate acts. Where a party has overextended his privilege in the use of a corporate entity in order to evade contractual responsibility, the corporate veil may be pierced to render the individual defendant liable. There must be evidence of abuse of the corporate form. You must determine whether a defendant disregarded the separateness of legal entities by A, commingling on an interchangeable or joint basis, or B, confusing the otherwise separate properties, records, or control. Sole ownership of a corporation by one person or another corporation is not a factor, and neither is the fact that the sole owner uses and controls the corporation to promote his ends. Whether a party in this case may be held personally liable for breach of contract is a matter for you to determine. And with that, I will just tell you to please retire to the jury room and resume your deliberations. All right, we'll be in recess until we hear further word from the jury. We're off the record.
Thank you, Judge. Oh, yeah, that's theirs. All right. Shall we go back in? Sure.
Oh, man. There's a way to do it with that. All right. This one is a double act. This is a double.
This minute, they may be back. I think.
Yeah.
Yeah.
Really won't. They won't care about that. Questions.
I need $10 a minute.
What is that? That's the only logical. Now, that also doesn't mean, that also don't mean that it could be. We'll give you that, because they can do whatever they want. They could say, we're gonna give you some of this, we're gonna give you some of this money, but it don't mean that you don't have to pay. A fuck ton
That's true.
to- I mean, I'm trying to,
Right.
I'm just sitting.
Henry.
Michael.
Reach out. That you did. No, I'm lost in this. But you see that a lot.
Yeah, I can see where it could flow. You said that you were not sure. Yours? Or this? Yeah. Oh, that's it. And it's around every day. That's just a month's case. We can do that. Politics. Yeah. I like these chairs. How you feeling? No, no. Who do you need to know about? What's your thoughts on everything? What? Oh, it's not legal, it's quite expensive. I'm not sure. Hopefully, I'm really ready to say that. I don't think the video, and the videos would be evidence, but I don't think it'd be dispositive. It's not really. Optimistic that I'm gonna be fine side of it. Good side of it. It's very, why something happens? You know, the box, all of those, things. He's optimistic. He's feeling good about optimistic. Yeah. Look at the bright side of everything. And what it means. Some of this. That's what, that's just what they say. Well, after this is closed, we brought it like today, discovered that at all. Regarding the look at professional years, you may find the evidence that if something to refresh your, they have to inspect. So once they inspect it, they move to have it, the discovery is closed.
Two tax documents. Yeah, you might go on and keep that 700%. Tax documents, the law says, the 917, 18,000. You also saw that interest.
I believe that's. What to do, calculated figures. That's yeah, for other ways, maybe. So, yeah, I don't know, my accountant or I choose accountant, I don't do the for. Because the important thing that you don't want to spend the tax to them because people money.
I have faith that will
People money. That's what you should ask all the tax it. I said, this one. Maybe. It's continuous current tax, the same thing.
But we didn't create a site.
Like,
It's continuous site action type. So.
But we put our best foot forward. Now it's in the hands of the jury.
continuous current taxes, you know.
So what?
For the 90. I mean, both can be done, and parents come Mr. Ray. It's continuous, same tax. Company.
Yeah. That's right. Well, that was my understanding. He was using the same, that we might have told him.
Maybe I told him, told her, or you know, told her something.
Okay.
Maybe I forgot, I don't know, I'm not sure.
Anyway. I was back to the courtroom.
Yeah. Oh, yeah, because he came back, we were gone.
He keep this always feeling. When you come.
Uh-huh.
That's even given the tax.
That's right. Never asked.
8A RP, isn't that all? Ask if I want to enroll. That
$.
dollar.
Like actions. Like. Didn't see you out.
That should be a hearing. Hey, there. Gee, personally. Yeah. Your personal account, Or. Not. If you ask me, what house is? You say house number one, house number two, is house number three. You would put a lien on the house. So if the house is sold. Whatever's the right. Okay, so if you personally or no patient, and you ask you those questions, yes. That's correct. Just like. Doesn't just pay. You would have to find out what this about. Just like you do like it's how you have to get up. Now. See. With the original money. It would be almost impossible to collect anything from that because there's no like good easy money to get from. Does that make sense? So that yeah, so yeah. I'm missing. No. That's how it would be. Now. This is really extreme. Really extreme. But if you if that is a if personally, depending on how much it is, technically, well, this isn't gonna make sense based on your age and what would say. If you probably pay for a sleep position. Depending on what type of you probably won't be able to get it, depending on which one you buy. Hey, you know, if you have a bankruptcy. You might have to, the person that wants the bankruptcy, kind of like a judge, of trustee. They might say, okay, you have to sell this or sell that, just to make sure that the creditors can get paid. But I'm not saying all this scare you, Yeah, I don't know what's gonna happen. If they say, just give me the lay of the land, what could happen? Then if they come back, and say, "Yeah, whatever the number is. And if they say. You personally have to pay it, not the LLC, then these are things I'm giving you a heads up on. You're just gonna need this both sides. And if they say, he owes you money, you have to do the same thing to them. And try to collect. That makes sense? So if it's you, they have to try to collect it, or you just voluntarily. If it's him, you voluntarily pay it, or you have to collect it. If it's the LLC, it doesn't really matter from what I can tell, because I don't think the LLC has anything. Just imagine if that, this is what I'm like, right? Because it would come out and I did about that. It's not only that's not a mistake. Really regardless about that. And see what's happening. And that's all. And they saw that. You also. But if they don't see that word as a separate thing, I think they have a hard time figuring out what to do. Yeah, I mean, it's. It's fine. Let's see how that is. Oh, yeah. It's amazing. Right, so the only. Right, so it's like, what would you tell me when you sell it without? 236, yeah, policy. 100 something, the 236. So. Are you really telling me that I was hoping it were all? Well, if you only, well, okay, fine, we'll pay you 50. Yeah, we're never gonna pay. You know what I'm saying? Almost like. It was just. Correct, yeah, correct. Correct. And I can't think of another song other than like the best, which is essentially like all the Andy White's authority matters. Because if I say, what if they, and they argue, include the guys below to make percent all. How do they put one zero? So you just, but then they, so so if you want to break free. This is you breaking free, that's the one, right? But then it would be. It's like, you have a, how do you know there's not gonna be some, here's the. Sweet in your stomach, you want to, yeah, the only way you, only feel style. You, and you, that's what it's doing. Have your, that competition. So, you know, it's funny because you said news and movies. Well, maybe the other day, right? Yeah. Don't, like, it's almost like paradox, it's like the one, keep it up in mind, and the other. um, Stick to your convictions, right? You're typically well in certain things. You're typically. Whether it's working as a sleeper, right? Cause values, all that stuff. You're typically. All the team company exact, you know, what should you go for every claim or not, or for any, right? And I'm like, you're telling me, you guys were just so open-minded that the other people were arguments for that much more choice. It's like, there should be so much, there should be so many. Most of them just like $40 is anything. That's true. Right, and that's what I'm saying, they just, they take. $500. Oh, yeah. Yeah. Once you. How do you make stuff that you can go off? I know it's one long night or something, just, yeah, that's. At the end of the day, at 5 o'clock, let's say, it's just like 5 o'clock on. So it's 2 hours. Something that's weird. Yeah, but also, how they go on. So. No. Actually, no, there's something that's out of the conquered. Yeah, so, you got, yeah, I'm sure I'll do it. Yeah. This icons for that. Yeah. Okay. Now, if I said, well, I don't want, I don't think you should. At least I know that there's something about it, right? I don't want you to do things.
Yeah, maybe, yeah, you have to look at this. Oh, I think it would be more. Well, and to me, it's like, you know, everything. It's like,
Well, then that's, it is a forcing, then how come people?
But you know, but watching it the day after, that's what, the live stream. So from YouTube,
It didn't his parents.
yeah, well, he showed it yesterday, so the day, so, oh, no, that's your biggest trouble. Then, that should have. Remember, I know,
Right, so it's easy to watch.
that's what I'm saying, that's the part I'm not alone, and recording, you know, I can watch. I understand. Some started, my next. Do it all, because we got to keep it all. There was. Supposed to.
Right.
So we go back.
Yeah, and you know, and that's what it is, and that one is.
So I think it's like. So you go back. And see that.
Right, I know, right.
It's inside.
Yeah.
Or is there something that we has to.
And I'm interested. Are you sure? I remember where they're like, can you heads up?
Yeah.
But these now.
Yeah, no, that's. all. Yeah.
And
no,
the
that's-
Constitution,
The live stream was
7, 8,
archived.
7. 7, 13%. You should really wish out. That was our time. I could go back and watch that.
And tell you, even the.
I don't remember knowing my. And even those on other podcasts, like listen to a public podcast, and then to your point, how did I watch it?
That's what it is, could be PBS, God, the order. Well, no, that's a, okay, I forgot, you're, that one.
I understand, but I'm
That's
just,
not a.
but once again, it's like, well, okay, I don't want, I don't watch that.
Yes. Yeah.
Well,
no.
And
This
even
is,
that would.
I'm curious about this. That is, you know, needs to do. This thing, yeah.
How you were there now? They could read it for a while.
That is true.
So it's just.
Yeah. The direct announcer. Yeah.
They were still.
Would you, I know you see like Nicholas Hall, Lucy German. See it.
Yeah.
At least we go 95 in the direct.
Is that possible? Yeah.
Yeah, I think it's kind of new one. That's the last one he's done.
Okay.
I think he's.
I think yes, I think that's correct.
He seems to. So, I guess like. And the license, like. Yeah. So maybe like use it. You know, sounds so far back, it actually works. It's a good film. I know something.
Yes, I do not have to look at the law. You gave me no things, but it's like, and what?
So.
You said, how do you do it? Well, anyway, this guy's kind of like followers that I'm kind of like a pro game, almost like a figure, just kind of like, even though I don't think he's like personal thinker, just by interest in him. He's just kind of a fixture in like the world. Because according to the guy, pretty quiet. Long time, but sickness. That, and he just said, well, all he did was.
I want to move on. That's sorry.
You
know,
speak
Professional.
Yeah.
I love that.
Yeah. I like this. Any lies, can't give any speaking lies. I think so. I think all the other times he just shakes his head, they won't even go like. Right. I mean, I got you know.
So you could even get partner. I was thinking
I
about
think he's
this.
alive. I think he's alive.
But you're flying. The teaching.
Oh,
That's
okay.
what it says.
Says yeah, that one.
I mean, big guys like that, I guess all the.
I know who's supposed to be his kid. It's a basketball player, with the weight on, it's just like,
Well, looks like they've got like shows.
okay, yeah, and the kid is the same guy that was one of the movies, like basketball movie.
It was pretty good.
It was a, I watched like the first 25 minutes. Wayne. Now, I understand being,
I'm just gonna figure it out for that stand.
yeah, that's right, that's the good line, especially. Um. I just thought like, for a serious movie, if it was the same, that Clint Eastwood was actually, and the curve, and the curve. And then for a joking movie, it seemed a better, yeah. And then if you did the same movie, but it was comedy, I was like, this is the movie to scout. Out with Brooks and everything. If you go, I felt like there was a better one on the series, better. So I understand how old they're up there. And I remember seeing that today, I think, early. There's like a rain, because of these, that's so much, I watched all the movies. So I understand, like, nobody believed when, like, if they were. Right, I get it, like, no one, okay. And I also understand that, I, it's. Like, anything you'll say about people, right, okay, well, once I'm on watching the other beach. And that's the area. But it was the mayor of like, we did that technically like the city that was in on one movie, but right? Yeah, yeah, and so they had him in the booth, and just again, like so casual, but again, because it's him, you're like, I think it's true, right? So they always go to like the sun. It's really good, it's like, go to look at the beach, and it's super short, okay? Like 100 yards. And it's always like, me and I didn't get something done. It's always like, oh, that one was close. So they're like, you know, give me that one, or that was the big like. So. And I'm like, of course he does, of course, Eastwood, of course, but Eastwood is like unlike those other guys, we kind of just kind of seems oddly specific, and you know, he's like, yeah, he's just obviously. So. I know, it's bonkers, dude. That's the I saw it in this field. Yeah, that's the last one I saw. That was how bad it was. I see it. It was shit. And he was that, you know, think about it. that was like, oh, man. It's great. It's just it. Yeah. Well, obviously, yeah. Yeah.
And then you showed that medical medicine.
Which part of
The like, whatever the option was.
No, he goes, no.
Yeah.
Yeah, he says, no, he said, no. You get shot on the step. Yeah. You the whole time in the world, you're it's like, I'm doing another thing. Why keep doing that? So, I'm gonna touch this. Get it, so much. To be fair, you didn't say, you did not say much of that. Now, I still haven't rewatched the one I can tell him about. I was like, he's like a secretly wants me to have there. I don't know, but okay, that one, I was like, that's interesting. It was a little meta because he's like doing the acting within the acting, using an impression of that character doing the, you know, all the things. Okay. Wow. Yeah, there's still. Yeah, and watch. I got something. Watch you go to the water song. Yeah, that is the normal thing. That's the normal, yes, that's the normal. Especially. And that's the most obvious. Yeah, you definitely. want to do it. You have one question right now. It's that question. Twelve, just the 12. 12, yeah. They're going. You know, 10 hours or 10 minutes. Like, haven't had these. Good or bad or whatever, like, let's just take a breath. And talk about it, you know, tomorrow, you know, what I mean, if they're going there. Cause there's gonna be options to explore, whether it's a new options for us, new options for them, settling debts, I mean. Right? I mean,
Oh, yeah. Oh, yeah. Wow.
gee. I assume. Yeah. Can you? Where it's like, somehow they have to run or whatever, but you don't even know, right? But, and so whether it's a text message, do you get a lot of text? They might say something so bad that you're literally like, I don't know. I don't know what it says.
I was like, aren't you coming down?
No, to be like, how's the case going along? Or random, or what about that application? Or what about that document? You get that one?
Yes.
Okay.
Maybe improved based on.
No, I'm talking about clients. Oh, my clients. Do you get a lot of messages?
Oh, so I know that fine.
Like, do you get a lot of messages and texts? Clearly they are a client, but you're like, it's like, how do, like, the message is so bad. It's so nondescript that you're like, first of all, who sent this? I'm gonna use Right. Or maybe it's an email that's like, thanks. It's a common name, Ali. Thanks, Muhammad. And you're like, which Muhammad? HP, you know.
Okay.
All I know is,
A little bit, I think I
Dude,
know.
it is bonkers. Bonkers for years and years and years.
Just like how's the case going?
Oh, like this. I get this shit all the time.
See, I think
Somebody
get
named
myself.
Kareem. I know that, so I've obviously had some communication with guys in my Snapchat. Some random numbers popping up, hey. Hi Justin, are you available today? you want me to go over the submittal of the application?
I do get some of that.
Dude, I'm literally like, don't know what you're talking about, like zero clue. Then, like, 2 days ago, I get one from my guy that does a lot of work with night, bachelor, right? And he just like, can you tell me what's next about the lease?
You have no idea.
And I'm literally like, dude, the lease, like. Oh, yeah, that's gonna make something up.
I would just say, shoot me an email, we'll talk about it.
So I literally am like, well, I kind of agree, but can you be more specific, like, what exactly do you mean by that? Like,
But when I do these plans to give out myself, that's.
oh, man, that's wrong. But to me, it's just, there's so much presumption that I know who they are, or I remember who they are. And then like the description's so bad, and I say, you might as well just leave a message being like, my name's Ali, how's my current? Well, let me just go to the vote at some 8,000 cases to possibly get it. So man, these clients, leave your point out, like, I had an appointment with Dr. Jones the other day. I'm calling on the status of my x-rays.
Yeah.
Like,
Right.
they're gonna know who that was.
I'm just like, pulse my nose.
Yeah, that'd be like, how's an x-ray? We
Right.
take 8 million x-rays a day. We help out.
This is a big deal, all the crowd going, that's. No, I guess because it's new stuff people always gonna. Sorry, I went for it.
I would, yes, sometime, but I wasn't even counting that element.
So if someone hired me, I generally would, I would do it a lot. That's my house. Okay, that's.
Maybe because I do something good, but you know, little too.
Yeah.
No,
It takes a minute sometimes. You tell you it is, but.
well, like that one, that text message. I gotta tell you, I
Just
can't
as
put
a-
it, I can't.
Well,
Well, I know one of the people on, that's copied on that message is someone named Kareem. But I gotta tell you, I can't put a face, I cannot put a face to that one. And then to just say the word application, I'm like, hey, this is, I'm just making this an example. If you recall, we're the new owners of the store at 123 Elm Street.
the place.
And and you helped us with that format. You want your double check or if it's submitted, yeah, like. Thank you.
Someone's, right now, Sure.
I
know you.
tell me what.
I said, it's my other song stuck in my head. Because I can bring
Like here's like this can just these Giovanni copy. I'm just starting by saying, don't know that. Called again, like this would be the first call. I don't even know how you can say probably. Like, there's no other messages from the guy named like. This is guy from you guys, business deposition. And I'm just.
Wait, this is big.
Is that good? Yeah. Okay, but when she calls you off the phone, such and such is on the line. Okay, it's going to take a message. What's the message? Cell number. No, it's the message. Yeah. Fresh.
That her, she's not getting them.
Sure, I'll give you the message.
I literally asked to take a message, not a phone number, I can just call her, I don't know how. How maybe, I have her. It's such.
You got some Dollar General. It might be cancer problem, but I want to get some practice. What they get this for. Tell me. I don't want it. Yeah, 2 seconds. This is this 2:30. Oh, make sure you're building your time, though, right? I'm tempted on this walk, the elevator, or all one of that. See what this is about. Walk a little bit. Oh, thank you.
Well, we heard it, so I said. They got this charges, but you gotta hold on to them. So we can do this. But the loss. You know, they don't know. They don't know. You know. Well, that's fine. Certain counties, because that's the way. That's the thing. So there. He's hoping now. He's hoping. Scary. Scary. So we can sustain. Inside.
I can be very simple thing. So we're burning. I'm trying to think how I was particularly you can. And it was a very beautiful second. But I'm not. I can be a little too fortunate. Yeah, it's pretty certain. So, you know, so here box. It's got 7 they only have 6 children as well. So they have fewer people on slot. That was trying to do. We struck out 3 when it goes on. Stays for about 3. And also everyone on the cabin like that. I'm good with that. You can do something from on the drive. That's the right. It's a percentage of makes it legal, or if you have some safe route, basically. You have, you can get like 1 glass of wine and get it. Even though you're not, you're not already. You go on. If it made you unsafe to drive alcohol, then you still do. That's the law. So in this case, our client had refused. So there was no evidence of this right out of holiday. We won't get evidence of that. Smell alcohol is bad, and she fell out. And he was speed. So they're saying it doesn't even the alcohol that you get. So sorry. That is what I know the evidence of that. My point is, of all jurors, like none of them socially. But one of them will then probably the same guy do something better. So. That was my question. Did you guys have a question? Okay, so they wanted to know, their question was, can you get the, can you tell us the law on when you can basically, when there's corporate protection against this law? Well, we don't we can hire individual liability. That was her question. So well, I'm not sure. Some ways I think it might be after us because they're the ones that sued me. So they might be thinking, well, we can in the house. Right, so this is, but we have good experience. If he was with me, was on that, I'll have, he won't be that long. So I'm not sure. You see what I mean? But that was the question. And we just gave them a new chart, it's not all here. We read a new thing. I don't think we were told. And you know, he's very, very much 2 hours. About the calculation of also the bottom. But in my son. This is a simple, right? Yeah, never clear. Yeah, no, let's go to the talk about this.
Correct. Yeah, for sure, for sure. You're right. I think we made that clear. All the money that you have to pay yourself. Well, they should, it's on the level. It's all just, it's like this. What he's got on each hand. It's got ocean. I mean, that's just what, that, I understand this also. It was evidence, we have evidence. Yeah. Right, all the documents are there, they have. I'm listening to that. Yeah, litigation. Court case. Yeah. Well, this contract, everything. Yeah, with Canberra, and with the series.
Start smiling.
I know the family is still, I know the things. Yeah. Then keeping the ship permeable. Right. You want to? No. It's a very big. When you do that, I see when you take. Oh, no. You can go. Take out. Yeah, so you don't know that business. I'll show you some photos. That you have the store.
You recognize it? It's. So, yeah, I think I have one when I was in middle school. It's a recreation. I love that. Yeah, no, I got it like 2 years ago. Right now, you know, the market is so other. I bought it. It's just a recreation. You know, that's funny, you recognize that. These ones, it's it's really online. Oh, yeah. Yeah, but it's one of when I was in, like I said, 6th grade, 5th grade. Waterproof. Cheap. It was only like $30. Yes. It's good. Yeah. That's it. I don't. But I'm really it's not that. That. It's cheap. It's cheap for the box. Oh, okay, okay. Gotcha, gotcha. So, yeah. Well, that's the fun. I feel like in this country, I feel like these would color $30. So it'd be $30. It's actually pretty cheap. Yeah. We still, when we try to, money. Okay. So that would have been $10. So that was better. Yeah, this kind of really wanted $1. Everyone's in their job. That was stronger than that. You know, $1 between like. Give you an example. This guy, $1. This is the currency. Yeah, so I'll get stronger. Oh, Spain. Yeah, so that's some people. Recognize it, yeah. Really, I mean, this was 5, 6. Yeah. I was when I was younger at school, I could keep a lot. Took care of. They have expensive watches. Always cheap.
Places and provide for more activation. And that is used. There's no having the real. And that's what my folder. That's there. Yeah. My son is now going to check out this. Oh. This is okay, sir. And you know, okay. That's it. You need the cyber. Okay. Okay. That's all. That's like a good deal. Yeah. I want to be in front of him. But we will come around. I talked to them about coming returns. Interests. I'll make that your very so. You know, the coming gallery, we look at. On my previous coming, I'm working, I am deploying them for the thing. Because then we said. I will keep on the 1 hour. People is having one there. When I joined my one. Another is going to empire. Some people who are another fighting. But we very short. This time and forward the shoot. Okay. And you must slow the do it. It's even be much an hour. I'm not sure that part of it. For this work. You can't do this for. School last year is a long one. I still think that's very. Okay. I'm not really talking about so it's very. So then, we'll do it by fun. Right. I know. This years. On the category of the trade. With the feet. Yeah. Starting to and the category of and whether the state. Yeah. More things of all. You know what? I should feel it better. I can't go about 10:30. That's not all. It's good. I'm gonna go work for 3 days. I have a bunch of emails. But yeah, that's not to compare our lives. So. Smart. Property. Getting less than always. Important disease because the common type of club. You get sold in some way. Everywhere but that way. That's where you to almost they will talk it on whatever we say one, it's done. I think always pass. But we use more and more. He's having 90 water. Oh, okay. So that's what I understand a lot of that. That was something. Okay. It's fun. Every time we will move that, it's going to be spending. I don't need love one thing. Okay. Yes.
Yeah. Okay. Yes, it's, we need to. Yeah. It's a good. Yeah. Very useful. Oh, Tim. Yes. Yes. Okay. Yeah. We only have one hour data terms. Pretty small. Yeah. Good. About the reputation. Yeah, it's not those guys. They were on close. Yeah. What is that? Yes. Can. Or in. Secondly. Yeah. Okay. Yes. Yeah. Yeah, they don't do litigation. They don't do court. It's all closing. What's a good thing about us? The speed, because it gets through down the hall, do the closing. And adjusted and I said, oh, we'll do lawsuits. Litigation. A little bit, not much thing. Yeah, we do a little bit, both of us, but mostly this kind of stuff. Go with it. He's a good man. Not bad. Okay, I put this on like one week. You have that, but I know I can do that. He's trying to. Yeah. Good. I'm gonna do it. Okay. Okay. Yeah, he told me a couple years ago, he was trying to tell me. Get it a little bit of stuff. Yeah. You could. But if you see people holding, if they dispute. Someone on this and it's good.
These are the, they're all, they're not those things.
Deputy Scott?
Okay, I see it.
Ready for?
Question. Yeah, I can slides. Okay.
What are the odds? And they called the deputies. What are the odds? What are the odds I walked in and said that?
Oh, y'all did?
So like, yeah.
Oh,
it's
y'all
just-
did.
it's
I
just
texted
that-
you.
No,
Oh.
no, we're literally just strolling. We're just walking around.
okay. That's so fun.
Dude, that took them what? Almost 4 hours.
Everyone asks 1:15 is the question.
In total, it's
It's
12
an
hours.
hour, right? Hour first. It's been around 3 more hours, so yeah, 4 hours. Ready, I think. Question. Yeah.
Just remember, no matter what, like Tim said. Options. Options. I just want the options. Oh, really, the options are that you actually have to be somehow get those.
Oh, yes.
It's usually the outside. I don't know what pancreatic cancer yet. I was doing some covered dental crackers in there, but. Maybe not.
Yeah, I'm excited to go find
Mhm.
That's nice and this.
Yeah. She'll go to Biden.
See this. Get that final. Here.
Down there.
So come to order.
Thanks, y'all. Please do. Do we email? I can get this back to y'all. Let me check in on Zoom. Do we still have our court reporter with us?
Yes, sir, I'm here.
All right, fantastic. On standby. We should be going on the record soon. All right, let's go back on the record. All parties and counsel are present, and I've been informed by Deputy Scott that the jury has reached a verdict. And so, unless there's anything to take up from counsel, I'll have the jury come in and we'll have the foreperson publish that for the record. Deputy Scott. Thank you, Deputy Scott. All right, members of the jury, I've been informed by Deputy Scott that you have been able to reach a verdict. And so I would ask the foreperson just to identify themselves by juror number.
Juror number 5?
All right, juror number 5, have you reached a verdict?
Yes, sir.
Was it unanimous?
Yes, sir.
Has that verdict form been filled in, signed, and dated by you?
Yes, sir.
All right, if you could hand that to Deputy Scott so I can inspect the form of the verdict, make sure it's been completed before we publish it. All right, if you could publish that by reading the verdict aloud into the record, and thank you.
We, the jury, find as follows. As to whether the defendants breached the contract with the plaintiff by failing to perform their duties regarding the 49% interest in the company, we, the jury, find in favor of the plaintiff as to defendant Mohammed Khan. We, the jury, find in favor of the plaintiff as to defendant in Nahar Investment LLC. If you have found in favor of the plaintiff, what damages, if any, do you find for the plaintiff? Restitution, $347,000, $733.26. As to whether the defendants acted in bad faith, have been stubbornly litigious, or have caused the plaintiff unnecessary trouble or expense to warrant reasonable attorney's fees and expenses of litigation, we, the jury, find in favor of the plaintiff. As to whether the plaintiff breached the contract with the defendants, we, the jury, find in favor of the defendants. If you have found in favor of the defendants, what damages, if any, do you find for the defendants? Actual damage, $26,357. As to whether the plaintiff acted in bad faith, has been stubbornly litigious, or has caused the defendants unnecessary trouble or expense to warrant reasonable attorney's fees and expenses of litigation, we find the jury in favor of the plaintiff.
All right, if you could hand that verdict form to Deputy Scott. And I have that available for inspection from either of the parties. And when the parties are ready, my
Can we
question,
approach your honor to?
you can approach to inspect. And when ready, if you could tell me if, one, there are any objections to the form of the verdict, and then whether there's any further need of services for this jury.
Plaintiff has no objection to the form of the verdict, your honor.
All right. Any reason why this jury cannot be excused on the part of the plaintiff?
No, sir.
Anything on part of the defendants?
No, sir.
All right, members of the jury, at this point, I want to thank you again for your service, the time you've spent with us. You're now perfectly free to speak about this case with anyone you may like to, but that's completely up to you. You do not have to speak to anyone. And if you have any questions about work or excuses or anything like that, let us know, but we'll be able to provide that paperwork if you need it. And with that, is with the thanks of this court for your time and attention, that you're excused, and we will see you next time. Thank you.
Here's a good judge.
All right, I will have a copy of the verdict form filed and made a part of the record. I'll ask plaintiffs to send us a proposed order
Yes, sir.
of a final judgment reflecting this verdict, and we'll scan a copy and send it to you all. And from there, if there are any further motions to be filed before the final judgment is filed, you can tell us by email and we can set up a briefing schedule if we need to. But other than that, is there anything else that needs to be on the record for today on behalf of the plaintiffs? Okay, on behalf of the defendants, anything else to address for the record?
Okay, nothing else then, Judge.
All on the same page? Understood. All right, then with that, we'll consider this matter adjourned. Thank you, counsel.
Thank you. Thank you.
Collectively owe him $347,733.26. Plus whatever that legal fee was, which I think was $37,000. So that gets us to about $384,732.26. Now, shockingly, they simultaneously said he breached the contract, but the damages were a number I've never seen before. $26,357. So if you take $26,357 away from that 384 number, again, using his legal fees as 37, that basically gets us at $358,376.26. That's what this says. Now, what I was trying to say many times, well, in the morning, and then when we were in the hallway, is this restitution bill. Okay, now, in all of our experience in contract law, okay, if somebody says, hey, I have a contract with you, you breached the contract, they would have to show this is the money that I would have made if you hadn't breached the contract, okay? Now, originally, they wanted to say, when